Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which, as one or two of you may be aware, is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. You can all sing along to our glorious mission statement, and we've now encapsulated this in a vision statement as well, which is to say that this is the only place in America in these polarized times where people of different perspectives can come together to learn about, celebrate, and debate the greatest vision of human freedom ever invented, the U.S. Constitution. How's that? Great. Well, as you know, those of you who have been here before know there are many evenings of great excitement here in constitutional heaven, but you're in for a real treat, and I am as well, because I have the huge honor and pleasure of welcoming back to the stage of the National Constitution Center not only our dear friend and valued scholarly advisor, Akhil Amar, but my first constitutional law professor. And I have to tell you that my passion for constitutional debate and love for educating Americans about this great doctrine was kindled by this great man in his class now many years ago. And he is just a model of a scholar, someone whose passion for making the text of the Constitution accessible to all Americans inspires and has shaped everything that we're trying to do here at the National Constitution Center. And he, I think, has done more to educate Americans about the importance of taking the text seriously than any other scholar in America. It is such a privilege to welcome him to the NCC. Please give him a round of applause. We are going to jump right in a moment to his superb new book, but I have a couple of plugs that I have to share with you. This is, as you know, a members-only event, and it is a sign of the irresistible benefits of membership in the National Constitution Center, which anyone can join just by going to the website, and you get to come to in-person events like this, and you have this beautiful brochure of upcoming members' events, which are similarly thrilling, including a breakfast, a meet the CEO breakfast. Can you imagine anything more exciting than that on May 28th? A special members-only tour of our upcoming exhibit, Speaking Out for Equality, the Constitution, Gay Rights, and the Supreme Court, which is opening at the beginning of June and is going to be the only exhibit in America that will present all sides of the constitutional debate over the meaning of gay rights, and it will open just weeks before the Supreme Court hands down its historic decision in the marriage equality cases, which were argued just last week. In addition to these great members-only events, we have just a panoply of spectacular events coming up this spring. Our traveling town hall events, co-sponsored by the Federalist Society and the American Constitution Society, are taking off next week, and we will be in Boston on May 12th, debating whether the Citizens United case was correctly decided. We're going to New York in July to debate the constitutionality of NSA surveillance, and we think that these great debates, uniting the two leading lawyers groups in the country, have the potential to transform constitutional discourse just like the Lincoln-Douglas debates did 100 years ago. And there's so much else coming on. Please check out the website for more to come. I've already given Akhil I've told you how meaningful it is to have him here at the National Constitution Center. He is the Sterling Professor of Law and Political Science at Yale. He clerked for Judge Stephen Breyer. He joined the Yale faculty in 1985. So I had you in small group in 88, and you were just 3 years into teaching. And basically, you're about a year older than I am or something like that. You started. Were you the youngest teacher ever at Yale?
One of them.
Yes.
Yeah.
And I want to start, he's the author of, I'm going to read the title of these books because I want each of you who has a love for the Constitution and wants to learn more about it. Seizure, The Bill of Rights, Creation and Reconstruction, America's Constitution, a Biography, America's Unwritten Constitution, the Precedents and Principles We Live By. Shall I start by recommending America's Constitution, I think, is the place to begin, and then go and read all of Akhil's other books, and I know you're going to want to read this one after we talk about it tonight, because this book, The Law of the Land, A Grand Tour of Our Constitutional Republic, has a thesis which is so surprising and innovative and creative, just as everything that Akhil does is, and that is to focus on the relationship between the Constitution and geography. Who would have thought before reading this dazzling book that geography was so central in the thinking of the justices who have decided the most important cases in history, as well as in people like Lincoln, who shaped its meaning? And I just want to jump right in with, your first chapter talks about Lincoln, and you talk about secession. And I have to tell you, ladies and gentlemen, imagine this. I've just started law school. It's 2 weeks in, and this great man, this great teacher, took, I think, 2 hours in your office after class. It was late at night, 7 o'clock, and the dusk was settling. And the question was secession unconstitutional? And Akhil insisted that it was settled at the time of the framing, that we, the people of the United States, rather than we, the people of the individual states, were sovereign, and therefore secession was unconstitutional, starting with the framing itself. And I, with the absurd overconfidence that only a first-year law student could have, insisted that no, it took the Civil War to settle that question, and it was open at the time of the framing whether we, the people of the United States, or we, the people of the several states, were sovereign. And in this brilliant chapter on Lincoln, you say that Lincoln basically believed that we, the people of the United States, were sovereign at the time of ratification, although you think he overstated the case to some degree for why that was so. Tell us about Lincoln and secession.
It's great to be with you all, Jeff. Thanks so much for your kind words. So Lincoln's my hero. He should be all of yours. We live in his house. The framers' house, built here in Philadelphia, was proverbially divided against itself because of slavery. It was a house that fell, really, because of slavery. We call that falling, the Civil War, and Mr. Lincoln rebuilt it, and he built it on an anti-slavery foundation. So the first chapter of this book begins with him and his vision, which is very much an Illinois vision. We're all living in the land of Lincoln. And I picked this season to launch the book because it's the 150th anniversary of Lincoln's passing, the end of the Civil War. I want to commend the National Constitution Center for its second founding project, which is all about putting Lincoln really up there, genuinely alongside Washington. We focus on the founding generation, but we live, as I said, in Lincoln's house. And the two most important constitutional decisions really ever, I think, were not made by a judge. They were made by Lincoln to resist unilateral secession. You know, if he hadn't done that, it's like, who would we be? Would we be? It's like asking who you'd be if your parents had never met. And the decision to free the slaves, which will lead, of course, constitutionally to a 13th Amendment and a 14th and a 15th, and this second founding project, this new birth of freedom. So, was Lincoln right? I say yes. The title of the book, The Law of the Land, is, of course, taken from the Supremacy Clause of the Constitution. Constitution describes itself as, it's this short little document, and it refers to itself on a bunch of passages.
Akhil, you have the wrong one. You have the National Constitution instead of the Constitution. There,
thank you. I actually don't have this version. I have an earlier version of the National Constitution Center document. So it describes itself. This Constitution, self-referentially it says, is the supreme law of the land, notwithstanding anything in any state constitution to the contrary, notwithstanding. What part of that do you not get, South Carolina? It's like I have kids, and sometimes I look at them, and my wife and I say, what part of no did you not understand here? If you don't like it, individually you can leave. You can't take the land with you. And that's what the founders understood. That's the text. Let me give you just one historical fact, and then I'll give you more about Lincoln, because Lincoln, I think, channeled the framers in powerful ways, and from a Midwestern point of view. We had a whole year in which the Constitution was deliberated on up and down the continent. We, the people, of the United States did ordain and establish this Constitution. We put it to a vote. Ordinary farmers read the thing because it was short enough for them to read it. Up and down the continent, they had to decide whether they were for it or against it. It just barely squeaked through in a bunch of places. In New York, the vote is 30-27 in the ratifying convention. In Massachusetts, in New Hampshire, in Virginia, it's very close. And yet nowhere, ever in this whole year, did any supporter of the Constitution say, why don't you give it a try? If you don't like it, you can leave. Money back guarantee. Now, what a powerful argument it would have been. If there were a money-back guarantee, don't you think they would have said so? Instead, in the Federalist 11, they say the union must be strict and indissoluble. In the text, they talk about a more perfect union, a union modeled on the Union of Scotland and England, which was an indivisible union. They call it the law of the land. They say any state, anyone who goes against that commits, even if backed by a state government, commits treason under the Constitution. Okay, now why did they do it, and then what does Lincoln add to that? So Lincoln basically is from the Midwest, and he understands that the entire region from the Appalachians through the Rockies drains through the Mississippi River. And you can't get your goods to market without going down the Mississippi, and you can't let a foreign power control the mouth of that river. New Orleans, it would have a chokehold on everyone in the middle of America. There's no defensible border, he explains, between Illinois and the states below it, where the culture of corn, the land of corn, meets the land of cotton. There isn't some natural defensible border, and so he says we can't allow this to fall into the hands of a foreign power. Why are Americans free? Well, the founders understood this, and Lincoln understood it, because there's no standing army in peacetime for the first 150 years in America in peacetime. Now, you have a hostile regime over the southern part of the United States, and now you're going to have two armies, facing each other, and they're going to fight over who's going to get the West because there's gold in them thar hills, and Lincoln says we can't allow that. You can leave if you want, but you can't take the land with you, you can't take the water with you. All Americans spent their blood and treasure defending Fort Sumter and these other places against the Brits. Those guns were meant to point out against our enemies, and you can't let just a local population unilaterally at any time swivel them around and point them into the rest of our bellies. Now, that's Lincoln's vision. Now, why? How does geography, I've given you a little bit about geography, but why would Lincoln especially understand that? Two things. One, he thinks that the Union actually helped create the states. If you're Robert E. Lee, Virginia's been up and running from the 1620s. It's 150 years old by the time the Declaration of Independence comes along. It's as old as Lincoln is for us today. You think Virginia created the Union. But if you're Abraham Lincoln, you're born in Kentucky, and your father's from Virginia, and your grandfather's from Pennsylvania, and before that from New England, although you're not quite sure which state, and you moved to Indiana, and then to Illinois, and when you move to these places, Indiana is a federal territory about to become a state. The Union is giving birth to new states in the Midwest and in the Old Northwest, like Illinois and Indiana. Okay, so you have when you move to Indiana, it's not a state yet. It's just you're an American. You're not just an Illinois person or a Kentucky person. So that's one idea that he has. The Union, what were its policies? They're going to have good land surveys, so you leave Kentucky because you're farming the land, but someone else maybe claims title to it because Virginia's land laws are all messed up and you can't really, you're just squatting on it, someone would say, and you can't really defend your claim unless you go hundreds of miles away and hire a lawyer in Virginia. You move to Indiana, you've got good federal land surveys and a commitment to public education and infrastructure. That's going to lead to the Morrill Land Grant Act, for example. Lincoln wants to connect America east to west with a transcontinental railroad as well as north to south. It's a very Illinois-centered view of the world. He's very much a product of the Midwest. And the backbone of the Union Army in the Civil War comes from the Old Northwest, Ohio, Sherman and Grant and Illinois. And finally, this land in the Old Northwest is free soil. It's free soil because of the Northwest Ordinance, adopted even before the Constitution comes into existence. The language of the Northwest Ordinance prohibiting slavery north and west of the Ohio River, that's going to become word for word for word the language of the 13th Amendment, which Lincoln signs into law, it isn't yet ratified when he dies. He's the Moses of our people. It's given to him to see the promised land, but not quite to enter it. And his signature isn't necessary, but he takes that Northwest Ordinance vision, and he, in effect, and if you've seen the movie Lincoln, he helps and ultimately get that into the Constitution. And it's a very Midwestern view of the world.
Okay, so it's powerful and well argued, but it's 27 years later, and I still can't let this argument go. So,
it's 27 years. After our first conversation, yes.
So there was another vision, and it wasn't a Midwestern one. It was from the Virginian James Madison, and in Federalist 39, as I tried to argue unsuccessfully back then, he talks about dual sovereignty and says that sovereignty is sometimes vested in the people of the entire United States and sometimes in the several states. And you acknowledge in the book that Lee had a more state-centric vision as
Robert
well.
E. Lee, yeah.
Is it possible that there was division at the time of the framing about who was sovereign? James Wilson, you argue so powerfully, was the champion for national sovereignty, but did Madison have a different vision, and did it take Lincoln to perfect and the Civil War to settle the question?
There were debate. Federalism is one of the big issues of American history, and this book is all about federalism. It tries to take states seriously and regions seriously. It argues that ours is a very vast and diverse republic, and things do look different in California than they look in Kansas or in Kentucky. So all that's true, and there are genuinely close questions in American federalism. It just turns out, happily, I say, for us and for Lincoln's memory, that secession isn't one of those close questions. James Madison never, ever, ever wavered on secession. He always thought it was unconstitutional. Here's a letter that he wrote to the New York Ratifying Convention while the eyes of the world were on New York. So let me set the stage. 10 states have said yes to the Constitution. It's going to go into effect. This is in July of 1788. So 10 states have said yes. But New York hasn't, and it's really close in New York. We don't know which way it's going to go. In the end of the day, it's 30 to 27. It's that close. So 2 votes switch, that change. In fact, strictly speaking, if 1 vote switches, that would change the outcome, because then it would be 29-28, and the presiding officer who's opposed to the Constitution will cast not a tie-breaking, but a tie-making vote, making it 29-29, and then the resolution fails. So it goes through in the end by 1 vote. And Hamilton doesn't know if he has the votes yet. He's trying to get the thing through. So the anti-federalists come up and says, here's the deal we propose. We'll say yes on the condition that there be a Bill of Rights. And he figures, look, listen, maybe I should go for this deal, because if New York says no, the Constitution, as a practical matter, will fail. How is it going to work without the Hudson River and the deep water ports of New York City? It's just going to be, it won't be contiguous. It'll be like East and West Pakistan, 150 years later. That's not going to work. So he's interested in taking the deal. And he says to Madison, well, why don't we, how about the compromise? And Madison says, no, you can't. And he writes a letter saying, this is the words of Madison, while the eyes of the world are focused on New York, because who knows whether they're going to say yes or not. He says ratification must be, quote, in toto and forever. That is how all the other states have ratified the Constitution and how New York must do it. So in or out, fish or cut bait, all deals are final. Once you're in, you're in. And as I said, no one in this entire year ever says otherwise. And think about it, if people are wavering, if there were a money-back guarantee, wouldn't you say so? But instead, they're absolutely resolute at the risk of losing everything. They insist that all sales are final. So happily for us, Lincoln was on rock-solid ground in emphasizing the words of the Supremacy Clause and its larger geostrategic spirit. I told you sort of why that's so, because you don't want basically people at any moment being able to leave the Union and cut a deal with the Brits or the Spanish or the French and then attack the rest of us. So Lincoln was right. He said a couple of things I thought that were a little too exuberant, so even though he's my hero, I'm going to tell you where I think he kind of went a little further than he had to. But bottom line, the most important constitutional decision ever made in America, he got it right, and for largely the right reasons.
All right, I have to confess, after all this time, when I read on page 18 the Madison quotation about each state's ratification being in toto and forever, I concede. Mea culpa. You were right all along.
But listen, Jeff, it's because you and folks like you, year after year, rightfully pushed back. That's, when you teach at a place like Yale, you have great students, and they push back, and they force you to refine the argument and make it better. And so thank you for that pushback.
Well, thank you for inviting, and I have to say the most exciting thing about studying the Constitution with you is that you just invited your students to hit you with everything we had and just to push hard and challenge you and let the best argument win. Yeah. And that was the most intellectually exciting experience I've ever had. It's now time to talk about Hugo Black. You also kindled my great admiration for Hugo Black, so much so that I named one of my sons Hugo, because Hugo Black is Akhil's hero, and he became mine. But as you note in this chapter about Hugo Black and Alabama, that's an unfashionable view. Hugo Black was dismissed as a sort of self-taught bumpkin by all these Harvard snobs for all these years. Yes. You say there's a central connection between Black's textualism and his great contribution to incorporating the Bill of Rights against the states, his First Amendment jurisprudence, and his roots in Alabama, and you think there may have even been a biblical connection. So tell us about geography and Hugo Black.
So I believe that the greatest constitutional figure of the last 150 years was this relatively unlettered fellow from Illinois, from the Midwest. Abe Lincoln had less than a year's formal education in his life, but it's unfair to call him unlettered, as I just did, because he's amazingly self-taught. Because he would go to debates and he would read books and reread them, and he had just a steel trap mind, but he was basically underestimated and dismissed in his lifetime by all these folks that had fancy educational East Coast degrees. And they really did underestimate Lincoln. And that story, interestingly, recurs in the next century. I claim I begin with Lincoln in chapter 2, that the greatest jurist of the 20th century was this hick from the sticks from Alabama, who didn't go to Harvard or Yale, in fact, who actually didn't even go to a standard law school for 3 years, who kind of basically went to high school, did a year or two of college, kind of, and then off to a non-standard 2 years of education at the University of Alabama. A former Klansman from Alabama is the guy who actually does more to redeem Lincoln's vision than anyone else. What we call the Warren Court is actually, I claim, the intellectual brainchild of Hugo Lafayette Black. This guy that you might not have heard of. You may have heard of Oliver Wendell Holmes, who went to Harvard, or William Brennan, who went to Harvard, or Louis Brandeis, who went to Harvard. And you're getting this picture of all these. And that's because Harvard has been telling the story. Or maybe Earl Warren. But here are the 6 things that the Warren Court does. And none of them was in place in 1936, the year before Hugo Black is appointed to the court as FDR's first appointee. Here's what the world looks like when Hugo Black gets on the court as FDR's first appointee. There's malapportionment in 45 of the states, and massive malapportionment in 40 of them. No, not one person, one vote. There's Jim Crow, de jure segregation, apartheid over much of America. The Bill of Rights doesn't apply against the states, but only against the federal government. Think about the important Bill of Rights cases. Almost all of the ones that you'd think of are actually when states have done bad things, not the federal government. There's organized prayer, recitational public prayer in the public schools. There's freedom of speech has almost never been protected by the Supreme Court, and criminal defendants have precious few constitutional rights. That's the world of 1936. The Warren Court will change all of that, and in almost every one of those things, it's Hugo Black saying it first, even before Earl Warren joins the court in 1953, way before Bill Brennan comes on the court later in the 50s, before Abe Fortas joins the court and Felix Frankfurter leaves. He's the guy who gives you one person, one vote, broad protection of free speech, applying the Bill of Rights, incorporating it against the states, getting rid of prayer in the public schools, and more generally religious equality. He, along with everyone else, gives you Brown versus Board of Education, but he's the one deep Southerner on the court that does that. He's the one that is more criticized by his social circle than anyone else, because what he's saying is unpopular. So, and the rights of criminal defendants, especially indigent criminal defendants, like Gideon versus Wainwright. He writes that, although he had laid the table for that in 1942, Betts versus Brady. So the story in that chapter is how people down south, they come from a fundamentalist tradition. They sola scriptura. They read their Bible, and they care about, and they teach it on Sunday school. And it's not a completely different vision than Clarence Thomas, also from the Deep South, a tradition of taking the text very, very seriously and paying attention to history and original intent, treating it as American scripture in a way that's maybe not very sophisticated or highfalutin, but it's very deeply felt by an American patriot from the Southland, Hugo Black. I'm in that tradition. The folks at Harvard kind of mocked that. They were a little bit more sophisticated about all this, but Hugo Black understood what Lincoln was trying to do. And he understood, having grown up in the South, that we weren't living up to the promises that got put into the Constitution, the second founding, thanks to Lincoln, because in the Southland, he really felt the failure of the Reconstruction vision, and did more to redeem Lincoln's vision than anyone in American history has. And again, he's a deep Southerner, a former Klansman who actually, deep in his heart, did not believe in religious intolerance or racial bigotry. He was a very great man, and some of you might not know his story. That's the one I try to tell in this chapter on Alabama.
Well, you've just done some Harvard bashing. Now, the Harvard side has reciprocated. Recently, Chief Justice Roberts was asked if he's concerned that all the justices come from an elite background, and he said they're not all from an elite background. Some of them went to Yale. But you discuss in your conclusion the odd fact that all of the current justices, in addition to their similar educational backgrounds, come from near New York City, and
Yep.
even when you focus on where they were raised, the geographic puzzle remains. 3 Amtrak Northeast Corridor cities plus San Francisco.
Yep.
And you also note, remarkably,
Philadelphia, New York, Boston, San Francisco.
so you've got them all from the same region, all going to the same schools, and you also...
3 from Yale, 6 from law school, 6 from Harvard Law School.
Nobody's perfect. So you also note that beginning with Theodore Roosevelt, 10 of our most recent 19 presidents attended Harvard, Yale, Princeton, or Columbia.
And 20 of the last 28 presidential elections, either the guy who won or the guy who ran against him came from one of those 4 schools. The last 4 presidents all went to Harvard or Yale, or both. 5 of the last 7 runners-up went to Harvard or Yale, or both. If you count vice presidents as well, people running for the vice presidency as well as the presidency, the last time we had an election in which one of the top 4 people, the 2 people running for president and the 2 people running for vice president, didn't go to either Harvard or Yale or both, 1968. So you're living in a world where, unlike the world that gave you Hugo Black or Abe Lincoln, our leadership path today very much travels through this very, very narrow gate called the Ivy League.
William Buckley said he'd rather be governed by the first 10 names in the phone book than the faculty of Harvard. Should we be concerned about this? And how does it intersect with your thesis about geography?
I think we should actually be concerned about this. Is very good for me that they all go to Yale Law School and Harvard Law School. I have 3 former students who are senators now: Mike Bennett, Chris Coons, Cory Booker. I have students who are presidents of the National Constitution Center. So it's good for me, but it's not good for the country. And it's not good for the country because I think that's too narrow a mentorship pattern. And I believe in diversity. I believe in geographic diversity. Every part of the country has something to contribute. I believe in, for similar reasons, that it does turn out, I hate to admit it, but it turns out that there are more than 2 good schools in America. And so I do actually find it a too narrow a pathway.
But you do say that the justices are redeemed, or at least geography resurrects itself by the fact that most of them were raised near port cities.
I do think there's just so many ways of slicing it geographically. Okay, so here's one way. It's north against south, and the same states that voted for Lincoln, basically in 1860, voted for another tall, skinny constitutional lawyer from Illinois, who gave a speech right here about race, right here, on this stage. And the same states that voted against Lincoln in 1860 voted against that tall, skinny constitutional lawyer from Illinois in 2008, 2012. So that's north-south. And the fascinating thing, of course, is that the parties have flipped. The Democrats have become sort of the party that inherits Lincoln's geographic coalition, and the Republicans have become the party of the Confederacy. So that's one way to slice it. You could do it a different way. You could slice it within states, and you could look at coasts versus non-coastal regions, and sort of, in Pennsylvania, as you know, it's Philadelphia and Pittsburgh, connected by a very different demographic. If you look at presidential elections by county, you'll see basically this is blue America. We start in D.C., a very thin strip of blue all the way up the Atlantic sea coast, around Maine, the St. Lawrence Seaway, down through the Great Lakes, the northern rim of Ohio, and around Michigan and Minnesota, down the Mississippi River, the West Coast, the tippy tip of Miami, where a bunch of New Yorkers have retired to, and New Jersey folks. 8 big Indian reservations where no one lives, but they look big on the map, and 8 college towns in the middle of America, like Boulder, Colorado, and Atlanta, Georgia. That's blue America. Everything else is red. So that's interesting. So the people who voted for the Constitution tended to be the people in the ports. The people who voted against the Constitution tended to be people in the hinterland. So that's a different. And I claim that ports like the great port city of Philadelphia are places that are connected to the world. They're places of commerce and trade. They're often centers of education and philanthropy. They're where peoples intermingle. California, where I grew up, is where north meets south and east meets west. So is Philadelphia. Philadelphia was always a more mixed place, and New York than New York City than other folks. And they're law towns, because law is about commerce and trade and clashes of culture. So Philadelphia is lousy with lawyers, and so is D.C., and so is New York City, and so is San Francisco, and so is Boston. And that's where the justices today, interestingly enough, come from. Now, that wasn't always true in the Constitution. That, for example, free soil laws are unconstitutional. So the Northwest Ordinance is somehow unconstitutional, or the Missouri Compromise, or the Republican Party platform. Why would they say something that preposterous? Well, here's one point. On the Dred Scott Court, 5 of the 9 justices came from the slaveholding South. Even though that region had only 1/3 of the free population, it had 5 of the justices. That Supreme Court was malapportioned in a southern direction. And one of the reasons it was is because the justices rode circuit back then. And so the South had sort of, you had to apportion your justices based in part on the roads that they would have to ride and the swamps that they would have to cross. And because the South had crummy roads and bad infrastructure, they had sort of smaller districts because it just took longer to get from point A to point B and disperse cities. So what that meant is the South had more than its fair share of justices, which meant that the Dred Scott Court was really tilted toward the South. Today, we don't have circuit riding anymore, so there's no Southern seat. We have demographic seats, the woman's seat, or the Jewish seat, or the African American seat. But interestingly, most of our justices today come from coastal places, and they went to basically Ivy League schools. And that's just like an interesting geographic fact.
California is next. Anthony Kennedy and the idea of equality. First of all, my geography is terrible. Sacramento is not on the coast, I think.
It's not too far from the Bay Area. So I'm, okay. Well, see, what I admit is you're from Manhattan, growing up. And
I'm from the only borough of Manhattan that's not represented on the Supreme Court. I'm from the Upper East Side, and I feel disenfranchised.
Well, Staten Island also, but you know, if you're a Gotham person, you think of Newark as an extension of Greater Gotham. You might even think of New Haven as, you know, part of the catchment basin of New York, because the Metro North goes all the way to New Haven, and you kind of have a certain imperialistic view of Greater Gotham. Now, I'm a Bay Area kid, and so I think, well, that's San Francisco and Berkeley and Oakland and San Jose and Silicon Valley and the Peninsula. And yes, our sphere of influence extends all the way to basically Sacramento and Tracy and Stockton. So as this Bay Area person, I do have the same thing that Gotham. But Tony Kennedy grows up in Sacramento, and he goes to school, undergrad at Stanford, before he goes to Harvard Law School. And on the bench, he sits in a court that meets in San Francisco, the Ninth Circuit Court of Appeals. And my claim is a couple, two or threefold. One, that he's a Lincoln Republican, and you see still the influence of, because there are not so many of them, because today's Republican Party has become the party of the Confederacy to some important extent. But there are a few Lincoln Republicans who were on the court: John Paul Stevens from Chicago, David Souter from New Hampshire, Harry Blackmun from Minnesota. Kennedy is in that tradition, because, and they can be so on the court, but in elected politics, all the Rockefeller Republicans from our childhood got pushed out of the party. The Arlen Specters from Pennsylvania, the Jim Jeffords from Vermont, the Lincoln Chaffee from Rhode Island, they kind of got pushed out of the party. So one, he's the one Lincoln Republican. Two, who's Chief Justice, who's governor of Sacramento when he's growing up? This Lincoln Republican named Earl Warren. So Kennedy is growing up in Warren shadow. Warren visits the Kennedy household on multiple occasions. Kennedy is a page in the California legislature. Kennedy is a little bit Ronald Reagan, but he's also a little bit Earl Warren. He's kind of halfway between. He's a Northern California Republican. And he today, was thinking about Brown versus Board of Education, which is an Earl Warren case, and Loving versus Virginia, which is an Earl Warren case. He talked about both of them last week on same-sex marriage. And isn't it, it's not a coincidence, I believe, that the one Republican on the court who most gets it on gay rights comes from Northern California, where we get it on alternative lifestyles. And so there are the four liberals.
What do you mean by get it? Constitutionally?
Meaning understanding equality and the equality and dignity of our friends who happen to be, frankly, born gay. Kennedy feels that, I think, in a way that's very authentic. He grows up, and I grew up basically just down the road. Walnut Creek isn't quite Berkeley, San Francisco. It's kind of absolutely halfway between San Francisco, that's where I grew up, and Sacramento. But Northern California is a milieu renowned for its respect for alternative lifestyles, and especially sexual freedom and equality.
You predict in the book that Justice Kennedy may write a landmark ruling for a divided court upholding marriage equality. On what grounds do you think he will do so, and how will his California upbringing influence his constitutional reasoning?
There have been 3 Supreme Court cases affirming gay rights. One is called Romer versus Evans. It was about a Colorado state constitutional provision. Anthony Kennedy wrote the opinion for the court, 6-3 affirming gay rights. I think that's 1996-97. A second one in 2003 is a case called Lawrence versus Texas, which the Supreme Court said states can't prohibit consensual sexual relations between consenting adults in private, and gay or straight. Anthony Kennedy writes for the court in that case, also 6-3, I believe. And then 2 years ago, in a case called Windsor, the court says the federal government has to respect same-sex marriages that are legal in states. The Defense of Marriage Act, to that extent, the Federal Defense of Marriage Act is unconstitutional. Anthony Kennedy writes that one. It's 5-4. In all of these, Justice Scalia dissents in a very angry, sharp dissent. Justice Scalia and Justice Kennedy are both appointed by Ronald Reagan. They're appointed within 2 years of each other. They both happen to have grown up in the Catholic Church, but they actually represent, I think, rather different visions. So having read Windsor, having read Romer, having read Lawrence versus Texas, I think that it wouldn't be shocking to me if Justice Kennedy wrote the fourth in this series, just as Earl Warren wrote both Brown versus Board of Education, ending apartheid in education in 1954, and wrote Loving versus Virginia in 1967, ending apartheid in marriage. And those were 13 years apart. These 2 great Warren Court bookends, this liberal Republican in the Lincoln Republican tradition from Sacramento. And if you heard oral argument last week, Kennedy actually mentioned those 2 cases. He said they're about a dozen years apart. That's about how long it's been since we've had same-sex marriage in the United States. So he was openly musing about these 2 cases and the timing between them, and in effect saying, you know, because we call it the Roberts Court, but in everything except the Obamacare decision, really, the big decisions have really, the swing justice has been Kennedy. We're living in Kennedy's world. I think it's actually a pretty attractive vision. I defend a bunch of his decisions, including Citizens United. So you can have at me in Q&A on this. But the chapter is called Anthony Kennedy and the Ideal of Equality. And the first part of the chapter was actually based on a lecture I gave in Sacramento in Kennedy's honor 20 years ago, and then I try to update it, saying, and here's what he's done since. I think it's the same person. And who knows what he'll do this season, but stay tuned.
I want to ask you what you would say to Justice Kennedy about his decision in the McCutcheon case, where you kind of disagree, but we have so much else to get through that I'm going to ask our great audience to read it to find out. There's 2 superb chapters on the Fourth Amendment, and the first, which is one of my favorites, is about Massachusetts, a Bay State view of the Fourth Amendment. You mentioned Chief Justice Roberts in a recent unanimous decision about cell phones. He quoted James Otis's famous speech in Massachusetts on the writs of assistance, and John Adams' statement that at that moment, the child independence was born. But you say that Adams was wrong, and he was influenced by the fact that he was in Massachusetts, but in fact it was another series of cases that happened just a bit later, namely the Wilkes case in London, that really animated the framers. Tell us about the Wilkes case and why that and not the writs of assistance were the central concern of the Fourth Amendment framers.
So in 1761, there's this episode that unfolds called the writs of assistance controversy. And the great colonial lawyer James Otis argues the Patriot cause. John Adams is in the room. And 50 years later, he says, that's when the child of independence was born. But no one at the time noticed any of this. And Adams doesn't write this until 50 years later. It doesn't make any of the newspapers. The Declaration of Independence doesn't talk about the writs of assistance. Just drafted right across the street there. You'd think if the writs of assistance in 1761 were a big deal, the Declaration would have mentioned it. The Fourth Amendment doesn't speak of writs, but of warrants. I don't think it was actually particularly influential at the time. So why did Adams say that? Because Adams thought he's the center of all things. And of course, he had to be in the room when the real thing happened. And it's all the better that Jefferson wasn't there, and it wasn't Virginia, and it was Massachusetts first, and he was in, from the beginning, and these Virginians are Johnny-come-latelys. And so you can see why Adams might think all of that, but the evidence doesn't quite support it, because no one else is saying that in real time. And Adams is this Harvard guy. Okay, so there is this Harvard thing. So then the first Supreme Court case that actually talks about writs of assistance as being important was actually from 1886. Gray's law clerk, this guy named Louis Brandeis, who also went to Harvard, and then Louis Brandeis says, oh, the writs of assistance were this big deal. And who's Brandeis's protege? Is this other Harvard guy named Felix Frankfurter, who in a whole bunch of cases say, oh, it's all about the writs of assistance. And John Roberts, who went to Harvard College and the Harvard Law School. So it's this total Harvard fabrication that it was all about Massachusetts. And Massachusetts was first, because I love Massachusetts. I did my clerkship up there, but they think of themselves as the hub, the center of all things, the hub of the American Revolution, the hub of the medical profession, the hub of the universe, and it's not quite so. Now it turns out not to matter that much because the court basically has gotten it right. But here's who was a big deal: a fellow named John Wilkes, a lawsuit that he brings, as in Wilkes-Barre, Pennsylvania. There's no Otis, Pennsylvania, you see. Wilkes-Barre, Pennsylvania, Wilkes County, North Carolina, Wilkes County, Georgia. See, we can learn things from geography, from a map. John Wilkes Booth, alas, is named for John Wilkes. Ashley Wilkes in Gone with the Wind is an allusion to this. The judge in the case, these famous English cases that everyone in America does pay attention to, 1763-64, a little bit after the Otis affair, the judge is named Camden, as in just 8 blocks from here, Camden, New Jersey, Camden, Maine. Our friends in Baltimore, the Orioles, they play in Camden Yards. Camden is a very big deal, and Wilkes is a very big deal, and you can see it on a map. Otis, not so much. And the last chapter is actually the story of Camden. You've heard about the great William Penn, and the great city of Philadelphia. And then I say, well, there's this little Rodney Dangerfield estates, across the river called New Jersey, and this gritty little place called Camden. But actually, they've got a story to tell, too. Lord Camden was a very great man, the Hugo Black, the Earl Warren of his era. He believed in American independence. He believed in liberty. And I try to tell the story about how if we pay attention to what Camden said, actually it has really interesting implications for how we can protect Fourth Amendment rights in America today.
Gosh, you see how this great teacher, just by uncovering these stories, can bring the paradigm cases behind the Constitution to life. There are phenomenal questions for the audience, and I better start asking them because they're so good. Here's the first one. Didn't the importance of geography also motivate Jefferson vis-a-vis the Louisiana Purchase? We moved west, closer to Spanish colonies, got a route around Appalachian Mountains, etc.
Right. So most people are taught, say it with me, just like nonpartisan, the most important constitutional decision ever, Mrs. McGillicuddy taught you in 8th grade, was Marbury versus Madison, right? Now, Marbury is not, in my view, barely makes my top 10 constitutional decisions. Yes, there's judicial review, but judicial review was established actually in America before Marbury. States were doing this, and as a matter of state constitutional law, way before Marbury. And after Marbury, the next time the U.S. Supreme Court strikes down an act of Congress, which is what Marbury is all about, is until Dred Scott, 60 years later and 50 years later, and Dred Scott is all made up. And what's the issue of liberty involved in Marbury? There is no issue of liberty. It's about original versus appellate jurisdiction, and nothing could be more boring than that. I wrote a whole article about it, and it bores even me. So Marbury is not that big a deal. What is the most important constitutional decision ever? I told you the first two, because I didn't say constitutional case. I said constitutional decision. The most important constitutional decision was Lincoln's decision to resist unilateral secession and later to free the slaves. So those are the big ones, okay? Now, once you understand that, I say that Marbury wasn't even the most important constitutional decision of 1803. And what was? Well, your audience member knows. The most important constitutional decision of 1803 is called the Louisiana Purchase. Presidents are huge constitutional decision makers. Even if you think judges are important, in the Constitution, presidents pick judges, and judges aren't supposed to pick presidents. But see Bush v. Gore, and I have a chapter on why that was an outrage, a disgrace, a shonda, because actually judges were picking presidents rather than the other way around. I have a chapter on Florida and Bush versus Gore. So 1803 is a very big, Louisiana Purchase, that's big. Our friend Joe Biden would say that's can I say it on C-SPAN, BFD. And that's because
at the Constitution Center.
Okay, oops. But that doubles the land mass of America. It ensures that we're going to survive as a nation, that even if Washington, D.C. is burned to the ground and Baltimore and Fort McHenry almost falls, we can just retreat back, into the hinterlands, sufficiently because we have all this land to retreat back into. So it, in effect, ensures that the French aren't going to establish a toehold here, or the Spanish. We've kicked the British out. The Louisiana Purchase is a very big deal, and it's all about geography. It opens up, eventually, pathways to Texas and California, from sea to shining sea. This book is very much in the Woody Guthrie a tradition of, California to the New York Island. Yes, Louisiana Purchase. And Jefferson, his principles are strict construction, but thank God he actually is a hypocrite. He doesn't follow his principles because he would have been a fool not to grab, all this territory. So yes, great presidents make important constitutional decisions that determine whether we exist as a nation. Louisiana Purchase, very big. Emancipation Proclamation, very big. Lincoln's decision to resist unilateral secession, very big. Marbury versus Madison, much smaller.
We have a Second Amendment question, which I will read in a moment. You have a chapter on Wyoming, a Rocky Mountains view of the Second Amendment, which concludes in a very timely fashion by saying that the founding and Reconstruction periods might provide a special focus on the concerns of African Americans in local police departments.
Yep.
So maybe you can tell us more about that in the course of answering this question concerning the Second Amendment and the search for its original intent. You go back to the founding of the NRA and Reconstruction. Why not go back further to the Virginia Declaration of Rights, Section 13, the actual origination of the intent of the Second Amendment, a well-regulated militia? There is no mention whatsoever of the right to bear arms.
Excellent. So, several things. One, let's pay attention to state constitutions, because federalism is important in America. And so what was invoked is, well, what were the Virginia counterparts to the Second Amendment? In my Massachusetts chapter about John Adams, I tell you about the language of the state search and seizure provisions of the Massachusetts Constitution of 1780. There's an amazing interactive display over here where you can just push buttons on a screen and see state constitutional counterparts to various federal constitutional language. This is a Brandeisian point, and Jeff is writing a biography of Brandeis. This is about states as laboratories. Almost everything in the federal Constitution, from start to finish, states did first. States had written constitutions first, and 3 branches of government, and bicameral legislatures, and separation of powers. I just told you they had judicial review and juries. The framers stupidly forgot a Bill of Rights when they drafted the thing, and that was an obvious omission because states had bills of rights. States got rid of slavery first, some of them. States gave blacks the vote first. States gave women the vote first. So almost everything in our constitutional tradition, states have done first. Okay? So one point is, well, let's look at state constitution. Suppose we didn't have a Second Amendment at all, just thought experiment. Almost every state constitution has a provision about arms in America, today in America. And today's state constitutions aren't just about militias. And I don't own a gun, guns scare me, but in almost every state constitution, there's a right to have a gun in the home for self-protection. It's part of our American tradition, even if we didn't have the Second Amendment, because we believe in unenumerated rights, don't we? And one way to find unenumerated rights is to count, to look at what's said in state constitutions. I had a great student about 27 years ago who wrote a student note about unenumerated rights and how you could find them in part by looking at state constitutions. That's the student, actually. That's his
He inspired
student note. So look, liberals believe in privacy, for example. That's in state constitutions, but it's not necessarily enumerated in the federal constitution. So if liberals can have unenumerated rights to privacy, even if there weren't a Second Amendment, I say conservatives can have it for guns. You know, liberals want sex in the home, conservatives want guns in the home. Give them both what they want. This is America. You know, let's live and let live. Let's be tolerant in the Northern California tradition. So that's one point. Even if there weren't a Second Amendment at all, there would be an unenumerated right to have a gun in the home for self-protection because every state has so. It's part of our American ethos. Second point, forget the founding. You live in Lincoln's house. We talk Jefferson. Jefferson dies a slaveholder. He doesn't free his slaves. Enough with this Jefferson stuff. Okay? You live in Lincoln's house. Lincoln reinterprets Jefferson. 7 years ago, our fathers brought forth on this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal. I'm wearing my Lincoln tie. You see, this is the Gettysburg Address. I got it right here at the National Constitution Center.
Extraordinarily tasteful and cheap as well.
A very good value, actually. It holds up very well. So, Jefferson said all men are created equal. That's what he said right over there, Independence Hall, but he didn't live it, he didn't breathe it, he didn't do it. Lincoln lives it, breathes it, does it, and he gives us a second founding. That's what the new National Constitution Center project is all about, celebrating this second founding, this new birth of freedom. And in that new birth of freedom, the Bill of Rights applies against the states. That's what Hugo Black understood. The original Bill of Rights was only limiting the federal government. Think of a Bill of Rights case, you know, that comes into your head, whether you agree with it or not. Almost every one is actually not a Bill of Rights case. It's a 14th Amendment case. The First Amendment's only about the federal government. Congress shall make no law of a certain sort. The 10th Amendment limits only the federal government. But all the cases that we think about, Brown versus Board of Education, that's Topeka, Kansas. Mapp v. Ohio, that's Ohio. Gideon versus Wainwright, that's Florida. Roe versus Wade, that's Texas. Lawrence versus Texas. Griswold versus Connecticut. These are New York Times versus Sullivan is Alabama. We live in Lincoln's house. And Hugo Black's, it's a 14th Amendment world. The framers didn't even use the phrase Bill of Rights to describe it. We call it the Bill of Rights because John Bingham and Abraham Lincoln's allies called these early amendments the Bill of Rights. That's why we call them that. So, once you understand that, in Lincoln's generation, the framers of the 14th Amendment believed in the Freedmen's Bureau Bill of 1866, which is a companion to the Civil Rights Act of 1866, both of which are companions to the 14th Amendment proposed by Congress in 1866. This is a direct quote from the Freedmen's Bureau Bill. Every citizen is entitled to personal liberty and personal security, quote, including the constitutional right to bear arms, unquote. No mention of militias, and here's what they were thinking of. They didn't love militias. Militias, you know, took up arms against Lincoln at Vicksburg and Gettysburg. They don't love state militias anymore. They like armies, national armies. But they understand that black people, so it's not about the militia anymore. Forget the militias. Black people in their homes are entitled to have guns for self-protection because they can't count on the cops to protect them. When guns are outlawed, only the Klansmen will have guns. And so that's the framers of the 14th Amendment's vision. The National Rifle Association is founded after the Civil War by a group of ex-Union Army officers. Now, that's part of the story. I say one other thing. The Second Amendment vision still is important. It's more about the military, and here's what it says. The military should look like us. It shouldn't be an alien occupying force. It shouldn't be a proto-military industrial complex. It should represent us, not them. It should do what we tell them to do. And in order to do that, it has to be representative, the way juries have to be representative. And the House of Representatives has to be representative. The militia, the folks who have the guns, and the people are one and the same. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be abridged. The people and the militia are one and the same. People who vote should bear arms in the military. People who bear arms should vote. Now, today, that's anachronistic. We're not Switzerland. We don't have a militia anymore. What are today's militia counterparts? At the local level, police departments, and they should look like the community. That's Ferguson, that's Baltimore, that's New York City. At the national level, we don't have militias anymore. We have Lincoln's Army, the Grand Army of the Republic, and it should look like America too. Women as well as men, blacks and whites, gays and straight. That's Colin Powell. That's Tom Hanks in Saving Private Ryan, who's a school teacher from Pennsylvania alongside a sharpshooter from Mississippi and a couple of fast-talking ethnics from New York City. That's not the founders' world. They had local militias. That's modern America. The Army should look like all of us. Colin Powell, as head of the Joint Chiefs, have women as well as men, gays as well as straights, blacks and whites. And so there's a collective vision to the Second Amendment and an individual rights vision, but you need to understand the founding and the Reconstruction, Lincoln, and the 19th Amendment, women's suffrage. Once women get the vote, they have a right to serve in our military on equal terms. And that's the story I try to tell in Wyoming, which is gun country, it's cowboy country, but you may not know it's also the equality state. That's its other nickname. It gives women the vote first. It's the state that first has a woman elected governor, Nellie Taylor Ross. It's the first to let women onto juries. They even in 1870, when it's still a territory, not yet a state, in Lincoln's, the Union is creating these territories that become states. In 1870, Wyoming promises women equal pay for equal work. Wow.
We have time, unfortunately, for just one more question, and here it is. You compared Justice Black to Justice Thomas as textualist. How would you compare their decisions?
If you want to come down to Washington, D.C. in 3 weeks, I'm going to be appearing with Justice Thomas at the National Archives. Maybe C-SPAN will cover that event. Justice Thomas and I disagree on certain things, but I think we share very much a fidelity to the constitutional project. We take the text very seriously. I find Justice Thomas underestimated in the same way that Hugo Black was underestimated, because we Yankees can be very smug about people who have Southern accents. And we think that means that they're just not smart. And that's how Lincoln was underestimated and Hugo Black was underestimated. I think that's true today of Clarence Thomas. I actually find his body of work very significant. I don't always agree with it, but he's not flashy the way Nino Scalia is, but there's a steadiness to it. There's also a humility to it. If I were to send Clarence Thomas something saying, I think you misinterpreted something, I think he would actually read it. He's very open to the possibility that he may have made a mistake early on and he doesn't want to keep making mistakes. I'm hoping, Jeff, that he's going to get involved with the National Constitution Center. I think both you and I are trying to get him involved in it in a big way. Here's what I can tell you.
We would be honored, and it would be so wonderful to get him involved in this great second founding Reconstruction project.
So when you go to, this is how I was going to end. When you go to his chambers, there's a portrait of Lincoln there. Lincoln is his hero too. Lincoln should be all of our heroes. And so it gives us, the story of the Constitution is what unites us all, North and South, East and West, liberal and conservative, Republican and Democrat, red and blue. That's what the National Constitution Center is all about. And so I'm hoping actually we can involve Justice Thomas more in the National Constitution Center in the years to come.
Beautiful. Ladies and gentlemen, you can see from this great teacher what it was that kindled my passion for studying the Constitution, made it the focus of my life. Akhil for inspiring me and millions of Americans to love and study the Constitution. I want to thank you, ladies and gentlemen. Please join me in thanking America's constitutional law teacher, Akhil Amar.
Thank you. Thank you. And thank you for these.
Come buy the great book, and Akhil will sign downstairs. See you soon. Thanks so much.
You made me look good. Thank you, pal. This was great. That was great.
I know. I subbed in my new introduction.
With David, yeah. That's wonderful. Hello.
Take off.
Oh, good.